case briefs, and so much more. LSData's got what you're looking for.
In a 1975 case that spotlighted the intricacies of antitrust law, William Inglis and Sons Baking Company faced off against rival ITT Continental Baking Company and several other defendants in the United States Court of Appeals for the Ninth Circuit. This case brought to light the stringent criteria demanded for a preliminary injunction grant: a likely victory, potential for irreversible harm, favoring hardship balance, and an injunction serving public interest. The original dispute unfolded when William Inglis and Sons Baking Company, among other baking companies, took legal action against competitors across 3 states in an antitrust case in 1971. Escalating their pursuit in 1974, they sought a preliminary injunction against 5 defendants, citing breaches of antitrust laws. However, the district court declined their request, leading to an appeal by William Inglis and Sons Baking Company. The appellate court then took the reins and determined that a comprehensive examination of the facts was superfluous. The bone of contention was around discriminatory and below-cost pricing for private label bread products as alleged by the plaintiff. In contrast, the defendants maintained that their prices were merely a competitive response. Ultimately, the appellate court annulled the district court's decision and sent the case back for review. The court directed the district court to reassess the case through the lens of the alternative test for preliminary injunction approval and related injunction relief matters. Carefully sidestepping any premature or undue influence, the appellate court neither endorsed nor rejected the granting of the injunction, instructing the district court to place its judgment in line with this directive.
Case briefs and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class